Yes, good evening to everybody. Welcome to the Law of Tort class, and today is the fourth class. And please read what I posted on the screen so that I could know that you are with me and I am with you. Both are traveling the same boat and reaching to the destination. Hurry up. Anyone can unmute and read what I posted on the screen.
Ubi just ibi remedium.
Over. There is only one thing is I wrote on the board, on the screen.
Ubi just ibi remedium is a Latin maxim meaning thereby. Ubi where just legal authority to do or to demand something. Ubi there is remedium, right of action. This maxim means where there is a right, there is a remedy, or there is no wrong without a remedy. Applicability of maxim. The law of torts, first one, second one, the Trust Act, third one, section 9 of CPC, entitles a civil court to entertain all kinds of suits unless they are prohibited. Fourth, the Specific Relief Act provides for equitable remedies like specific performance of contracts, injunction, and declaratory suits.
Professor Dr. Mohammed Saheb Hussain. Yes, generally this question may be asked in the short answer questions. So I would like to read because I told you that mostly the three maxims are said to be the foundation of the law of tort. That number one is which I have last time told you. I mean, the last class I told you that what is that? Which I told you in the last class. Number one, of course, this is the third one. You be just be reading. What is the first one?
Sine damnus and injuria.
Here I have told you that damnum sine injuria and injuria sine damnum. These are the two.
Yeah.
CB just CB remedium is the third one. Yes, for a wrongful act to constitute a claim for a tort and give rise to any liability. Suppose if a liability would be there in the tort, there should be 3 or 4 elements should be there. Number one, there should be a duty. Number two, a legal cause. And number three, the proximate cause also. And number four, the remedy also. Of course, sometimes in the books only 3 would be seen, and sometimes 4 will be seen. Because the legal duty is also an important factor. So the claimant must have this suffered an actual harm or loss or even an infringement of the legal right, within parentheses, with or without any resultant damage, as a consequence of the wrongful act of the tortfeasor. In the tortfeasor, we will say in the law of tort. What do you say in the crime? In the law of tort, we will say the tortfeasor, a person who does the civil wrong. But what about in the criminal law? Anyone? If you don't know, you say pass on. I will give the answer. Yes.
Accused?
No, I already told you, but I don't know why you have forgotten. It starts with a P. Perpetrator. Repeat. Repeat. Anyone?
Perpetrator.
Yeah, why you are taking so much? Sir, we could have to understand. No, sir, first we want to repeat it. Sir, if you can ask me, sir, could you repeat? Or could you say once? Then I will give you the perpetrator. So that is the way that we will say in the criminal law. The two maxims, injuria sine damnum and damnum sine injuria. The third one is ibi jus ibi remedium. And these are the things where we can make the law of tort. Then let us say the injuria sine damnum, we already discussed as SB versus White. Can anyone will say what is the rough facts of the case of the SB versus White? Sir, we told you no, sir, but we have forgotten, sir. Because this is the way that you have to remember the things. Otherwise, it is very difficult for you. Because I already posted you in the group. What is that? What is that which I already posted in the group? Anyone? Hurry up. Time factor, time management is a very much important factor that I told you. Because you know many things. This is the same thing which I made it. The time management is a mandatory while you are writing the law tort examination. because you know many cases. Of course, EES is there, but you can read it. There are many cases are there, but you cannot write all of them. You have to write depending upon the marks which are awarded over there. But don't try to fabricate the case law which are not decided in the reality in any court in India or abroad. When you cite the cases, don't write the facts, issues, and arguments are held. But overall, the case brief should not be more than 3 sentences in any case. That to be depending upon the marks you have stretch your answer. If the marks are 15, your answer should be lengthy. In other words, cut your coat according to the cloth. Hope you got me what I mean. Don't try to fool the examiner. If you do so, you will be the loser, but not the examiner. Don't try to show your ignorance to the examiner. Be a prudent person, please. It is the art of answering the university final semester examination. You know the many cases, but you cannot write in the stipulated time. That is a very important factor. But you have to recite the cases which are relevant, which are taught in the class. But don't cite that cases which are not discussed in the class, because the examiner always think that if you write the same cases, naturally he will be inflated. He will feel happy. So Asby versus case law, this is the case law regarding the franchise, the voting case law. A person wants to cast his vote, but the returning officer or a polling officer did not allow him to do so. There the legal injury is caused even though no substantial damage is, because to whom that he is going to vote, he won with the bumper majority, hence no damage is caused, but there is a legal injury is caused over there, hence a nominal damages are awarded over there. The same thing, just EB remedium also comes in the picture, because where there is a right, there should be a remedy. If the right is violated, there should be a remedy should be available. So just EB remedium also come into the picture in the SB versus White, and the same case law I can use it in the damages where I can make it out. Nominal damages, the same case law that we could be used, because this case law will be very much useful in the three or four places. Number one, injuria sine damnum. Number two, just EB remedium. Number three, nominal damages. This case law can be used. There are 3 places it can be used. Is it clear? Say yes. Say yes. Sorry, we don't say yes. If you say yes, I could know that you are hearing me, so that I could proceed further. Say yes.
Yes, sir.
I have to
Yes,
say
sir.
yes also to you, because I don't know, sir. I don't know many people whether they know the mute and unmute or not. But anyway, it is a practice makes man perfect. Okay, anyway, the another example in the Indian context would be the case of the Bhim Singh versus state of Jammu and Kashmir. This case law that I already told in the beginning. This is already I told in the beginning. I don't know how many people will remember that. This is the case law about the MLA, that is in the Jammu and Kashmir, there is a assembly sessions are going on over there, but this fellow wants to go over the constable did not allow him to go inside the assembly session. At that instant, that Article 21 of the false imprisonment was curtailed to him. This is a legal injury is caused, even though that he was released after some time. But he filed a case against the high-handedness of the police, and the police will be held responsible. Sir, when there is a police, sir, why the state of Jammu and Kashmir, sir? They should write to the sub-inspector of police, or the circle inspector of police, or the superintendent of police, or the commissioner of police. Anyone? Anyone can give the answer? If you know it, you tell me. If you don't know it, say pass on. I will give the answer. Yes?
Pass, sir.
Pass on?
Pass on.
Okay. Sardana Vemana. Yes.
Subject.
Yes. Because police come under the state or central?
Means central.
Police.
State, sir. States.
Police
It
state
is a
commander central.
state. Police
State,
is
sir.
a state, and
State subject.
military is a central.
State subject.
So state
Central.
subject is there. Then say the state head is the state of Jammu and Kashmir. That is the party that will not commissioner of police. Are you following me? Okay, now that is the point which I want to share with you. Okay. Next, another case law is the Margetti versus William case law. In this case, a plaintiff Margetti and having a holding an account in the bank of a defendant, the defendant bank, though there was a sufficient amount of the money in the plaintiff's account, but the plaintiff check was dishonored. The self check is dishonored and not allowed to do the same without any sufficient reasoning, and hence the plaintiff filed a case against the defendant, which is the bank, and the bank would be held liable to pay the compensation because there is a legal injury is caused, even though there is no substantial damages happened over there. But still, we can use this case law under the injuria sine demnum. Under the same case law, also we can make it when the right is violated over there, and there should be a certain remedy would be available. That means it is very much close with the injuria sine demnum, which is UB just and UB remedium. Is it clear?
Yes, sir.
Very good. I appreciate. So don't worry. If you once or twice you read it now, you can more fast than me. Are you following me? And please keep in the mind. See, wherever I write, I am not writing more than 3 lines or 4 lines. Of course, here I wrote a bigger lines. But in other cases, I don't write 3 or 4, 5 lines more than. In the examination also, you should not supposed to write the 3 or 4 lines. Then how much you have to write, I will tell you later. Don't worry. Okay? Okay, another case law is Ashraf Law versus Municipal Corporation of Agra. Here also in the franchise case, the Municipal Corporation of Agra did not allow the voter for the casting his vote, and he filed a case against the municipality because the legal injury is caused, like the Ashby versus White case law. The similar facts are there, but it is in Agra. What is Agra famous for?
Taj Mahal.
Peta. Agra Peta, sir. Peta.
See, each one attitude is different. Somebody's very attitude is eating, that's why they say Agra Peta. Somebody's attitude is there to see the sightseeing.
Sir, Taj Mahal, sir.
And Taj Mahal. Why only Taj Mahal? Fatehpur Sikri also there. Buland Darwaza also there.
Yes,
sir,
sir.
we don't know, sir, because we have never gone. Why don't you go on the college trip to go to see the Supreme Court of India? Okay, now let us come to the Ashraf Law, similar to the Ashby versus White, and hence it is very close to the UB just UB remedium because a person right is violated over there and he should have the remedy. That means injuria sine demnum. Illegal injury is caused because he was not allowed to use his franchise, that is the casting in the vote. So that is the reason we can make it out, and he will be held liable to pay the compensation. That is the Ashraf Law versus Municipal Corporation of Agra, similar to the facts of the case law similar to the
Delhi Municipal Corporation.
Ashraf Law case law is similar to the Ashby versus White. There also he did not allow to use the franchise, and here also he did not allow the use the franchise. Now you tell me, Ashraf Law case is similar to the. Please speak.
Municipal
Ashby
Corporation of
White
Delhi
versus White.
Ashby versus White. See, the facts of the case law of the Ashraf Law and the facts of the case law of Ashby versus White are similar. I'm giving the answer, but you say, sir, mayor of Carport versus Pickles. Somebody is saying that comes under the demnum sine injuria. The damage is substantially caused over there, but there is no legal injury. Okay, injuria sine demnum is another case law we can there. It is about the trespass was observed in the Sain Das versus Ujagar Singh case law. The nominal damages are usually awarded, and the principle of the injuria sine demnum is applicable to an immovable property when there has been a justifiable intrusion on the property in the possession of another. Suppose when an immovable property will be trespassed in your land, like a tree trespassed on your land, you do have every right to cut the branches of a tree, or you can ask the people to cut the tree. Sir, if it is a mango tree, sir, can your children will allow you to cut the tree? Yes. If the mango tree protruded in your land from the adjacent land, your children will not allow you to cut the branches. Why? Yes.
Mangoes are going to that side, sir.
They want to enjoy the mangoes which falls in their own land. Are you following me? Yeah. So if anything protruded, it become a trespass, and hence nominal damages are awarded over there. Suppose a cheetah is behind you, and you entered in somebody's premises to protect yourself from your life. Can it is amount to trespass?
No, sir. No,
No
sir.
need, sir.
Then what is the defense you can take?
Life save the. So that's why trespass is at that time, sir. Before trespass is another one, sir.
You can take the defense of necessity.
Yes,
Okay?
sir. Yes, sir.
Okay, now
Yes, sir.
let us go to the second maxim. There is a demnem sine injuria, means damage without the legal injury. Here, well, actual damage or loss is suffered by the party, but there is no infringement of the legal right. Thus, in absence of the legal injury, the injured party has no claim whatsoever. So the famous case law is generally, we will come across Gloucester Grammar School case law that we discussed in the beginning, and the two partners would be there. One partner came out of the school, then opened the another school with the same name with a little difference, but he kept his fees very much less than many people from the first school. They taken the transfer certificate and took the admission over there, and thus the first school got the financial loss, but there is no legal injuries caused because the competition is allowed in the business. So there is no injuries caused, even though substantial damage is caused, because he lost the revenue and he could not have the money to pay the even teacher's salary also. That is the case law, which is a Gloucester Grammar School case law. That is a famous case law. Then Acton versus Bundle, there is another case law where the defendant landowner is carrying the mining operations on his field in the usual manner, ended up draining the water from the land of another owner plaintiff, through which the water flowed in the subterraneous course of his well. Suppose he is having a land over there, but he is having a mill, the mining operations are going on, and he digged that very down, and the water which is percolating from his land going to the another's land will be stopped. At the time, the adjacent land well will be drained, because he had made the more depth in the mining, the most of the water would be accumulated in his own land. And it is ruled that the defendant need not to pay any damages to the plaintiff, as the defendant was not involved in any infringement of the right of the plaintiff, and the defendant was in his complete right to use the water for his mining purpose. Suppose if you have the well, then an adjacent man also having the well. Are you following me? Say yes.
Yes, sir.
Sir.
Very good.
Yes, sir.
Suppose you are a very rich man and you made a very depth
Yes, sir.
inside the door, but the adjacent man did not make such a thing. So who made the depth? Actually, the water percolates in his own land without going to the land of the adjacent man, whose bore is not that much left. Can he bring an action against you because his bore is dried? Did you understand the question first? Say yes or no.
No, sir, I did
No,
not
sir.
get
No,
it.
sir.
But why you are not asking me? You have your own land. You have the bore, and the adjacent man also having the bore. You know bore well.
Yes, sir.
Yes, sir.
Yes, sir.
Now, what you did it, you made a depth more. So adjacent man, water is draining the bore. Can he bring an action against you?
Distance అనేది
No, sir.
100 meters ఉండాలి సార్.
No, he can't.
He cannot make an action against you because it is his land and he wants to make it a bore depth more. If you want, we can go more than his depth. But he cannot bring it up because there is no legal injury, even though substantial damage caused to him. Because what is the substantial damage? The bore is drained. Is it clear?
Yes, sir.
Yeah, that is why there is a injuria, there is a demnum sine injuria. Damage is caused without a legal injury. So that is the same thing which I want to make it out. The next case law is the Quinn versus Latham. And in this case law, it is the rule that the competition has no ground for the action, whatever the damage it may cause, provided nobody legal rights are infringed. The judgment in the guiding the principle for the cases related to the losses suffered by the plaintiff due to the increased competition because of the defendant's act. Here the business competition is allowed. Suppose, I don't know whether you are having here, but in other countries, no. there is a long distance buses are there run by the private people. So a person, he wants to keep the less amount also to get the more customers to him. Can you make competition? Can you make the less amount? Can you bring an action against that fellow? Why you are keeping the less amount? Answer is no. Because he wants to run of course, some people will run with the high cost. Because when you say high cost means naturally the luxury bus, Volvo, that is Volvo, and it is having the AC inside, and it is having a short call also, a small latrine also inside for short call. And they will provide you the Coca-Cola, they will provide you the biscuits and so and so. In earlier, we will also get in a Garuda and Rajdhani. Whatever the now? Are you following me what I said?
Yes, sir. Now the water bottle is supplied, sir.
Whatever the movie?
A movie also, sir, in Rajdhani.
Even I
Super
traveled
luxury
so many
also.
times. In the earlier, they used to keep the movie, but no movie now. Okay, anyway, because of the there are various other factors are concerned. So in the Cheshmore versus Richards also, the landowner, mill owner, said same thing, running the mill on his own land, and for his purpose he was using the water for the stream for the long time, but the adjacent fellow, the water is dried over there, but he cannot bring an action against this man because it is he who is using the windmill. Mill owner, he needs the more water, he dug his well very depth, then with that the adjacent man well is drained. ఒక క్వశ్చన్ అడుగుతానండి. ఐ వాంట్ టు చెక్ యువర్ ఐక్యూ. మీరు మార్బుల్ మీద వాటర్ వేసిండ్రు అనుకోండి, ఇనుకుతాయండి అవి?
ఇంకవండి.
No,
ఇంగ్లీష్లో
sir.
చెప్పండి నాకు.
నో సార్, నో.
It will not be dried out. It will not be evaporated. It will be like that only. Suppose if you put the water into the sand,
ఓకే.
what will
Sir, it
happen?
will sink into it. Water will sink.
దాని ఒక ప్రత్యేకమైన పదం ఉన్నది, అది నేను చెప్పదలుచుకున్నది.
Observe.
Water percolates from higher strata to the lower strata. I repeat, water percolates, P-E-R-C-O-L-E-A-T, percolate from a higher strata, layers ఉంటాయి చూడండి, ఏది ఎర్త్కి, from higher strata to the lower strata. When you dug the well in depth, the water percolates in your own well or in your own bore instead of going to the adjacent man and whose depth is less and there is more. తెలుగులో సామెత ఉన్న చూడండి, ఏంటిదండి? నిజము దేవుడు ఎరుగును,
నీరు పల్ల మెరుగును.
wherever the water would be there is steep, it will go down. If you make a depth would be there, percolates in the depth. Are you following me?
Yes, sir.
Yes, sir.
Yes,
Yes, sir.
same the Cheshmore versus Richard also, when in the mill he dug this well very well in the depth, then the percolation which goes to the fountain అంటారు దాన్ని, ఊటని ఏమనాలా?
Fountain.
Yeah, the percolation, the strata fountain, instead of going to the adjacent land, it will be in his own land, that the adjacent land well will be drained out. So he cannot bring an action because there is no legal injury is caused, even though substantial damage is caused to him. What is the substantial damage to him? The bore is dried or the well is drained. Okay. Of course, Mayor of Bradford Corporation versus Pickles. సార్, ఈ పికిల్స్ అదే పికిలా సార్? ఆవకాయ తొక్కు, ఉరికాయ తొక్కు, పచ్చడి, అచార్, లోంచా, the same pickle spelling, P-I-C-K-L-E, mango pickle, usarkaya pickle. Okay, the corporation of the Bradford was supplying the water from its well. Okay, defendant Pickles only adjoining land to the land from where the corporation Bradford was supplying the water. This filter bed ఎప్పుడైనా చూసారా అండి మీరు? వాటర్ ఫిల్టర్ బెడ్
Yes, sir.
ఒకసారి చూడండి సార్, రియల్లీ విల్ ఎంజాయ్ ఇట్. అక్కడ పెర్కులేషన్ అయితే చూడండి, from a higher strata to come to the lower strata to another strata to another strata, where you will get the very pure water. So when you go to the filter bed, you will understand the things. This is also a corporation of Bradford, also a bed which is supply the water to the corporation, the entire people who are there. The adjacent man would like to sell the land to the Bradford of Pickles, but he wants to sell it at the exorbitant rates. Who? Pickles. But the corporation denied it to buy the land. So what that fellow did, he did intentionally, he dug more well. He dug the depth more well. So the corporation water going over there, it will be drained out. Not drained out exactly, but it is minimized. Are you following me? It is minimized. The water flowing from his, because water ku strata untadandi okati. Oka strata nundi inkoka strata ku untadi. So in that strata, he dug it more. The water going percolation to the another adjacent land, it will be accumulated in your place only. So the Bradford brought an action because that intentionally that he dug his well because we did not purchase his land. Because his land is selling for the exorbitant rate. That's why they did not purchase it. And even though he did it, it is a only damage is substantially happened to the mayor of Bradford, but there is no legal injuries caused to him. So that is the Bradford Corporation versus Pickle case law. And when you say the Day versus Browning case law also having the same, Ashford Lodge is for 60 years old lodge it is. But the one of the partner came out and he put the Ashford Villa. It is a lodge, he say villa. But anyway, after some time he changed the name also. The most of the people coming from that place to this place, and he got the substantial damage over there. But now nobody would keep the same name because now the name is registered. Are you following me?
Yes, sir.
Nobody would keep the same name with the other shop name. At least you should say new. See, if you happen to see in the Nampalli, the Royal Lodge is there, very opposite to the Nampalli railway station. But now they bifurcate, the partners are changed. So one is Royal Lodge, another is New Royal Lodge. Have you observed any time? Please, when you go this time, I don't know whether this time they completely changed it or not. At least you add something, otherwise you cannot have a right to keep the same name. Are you following me?
Yes, sir.
So here also one of the partner came out of it and he opened the Ashraf Villa, but after sometimes he changed it to the Ashraf Villa to the Ashraf Lodge because Ashraf Lodge is having the more seniority. సార్ ఇంకెవరన్నా చార్మినార్ సిగరెట్ పెట్టచ్చా అండి?
No, sir.
No, because it's already registered. I don't know whether now the Charminar is no more in the market now. Is the Charminar cigarette is in the market or Golconda cigarette is in the market? I don't think, because they sold the company, Wazir Sultan company, to somebody else. Anyway, let us come to the point. Here also there is a legal injury is not caused over there, but the substantial damage is caused, but still we cannot bring an action against. Another case law is the Butt versus Imperial Gas Company case law. Here, he is carrying a business in the shop which had a board to indicate the materials in which he dealt. The defendant, Imperial Gas Company, by the virtue of the statutory authority, created a gasometer outside the plaintiff shop, and gasometer was erected, put up in such a way that it obstructs the view of the plaintiff premises. Suppose if your plaintiff premises is viewed up over there, then the plaintiff brought an action against to restrain by the erection of the gasometer. The plaintiff contended the action for the Imperial Gas Company has led him to suffer the legal damage and he was entitled to the injunction. It was ruled that the injunction cannot be granted for the injury complained by the plaintiff. Here, you do have every right to keep in your own place. But if it is protruded in somebody's land, then is a infringement of a right. సార్ మీ చెట్టు ఉన్నది, మీ చెట్టు వలన ఏమవుతుంది సార్, మాకు పక్కకు నీడ వచ్చి షేడ్ వచ్చి వీ కెనాట్ కల్టివేట్, వీ కెనాట్ గ్రో అవర్ నర్సరీ. ఓకే, ఇఫ్ యూ సచ్ ఎ థింగ్ డు దేర్, you have every right to cut the branches which is protruded to your land, or you will inform him, the owner only cut it, because there is a legal injury is caused to you. సార్ మీ చెట్టు గాలి వలన ఆకులు పడుతున్నాయి, బట్ ద చెట్టు ఈజ్ దేర్ ఇన్ హిస్ ఓన్ హౌస్. The wind, by the wind, if the leaves will falls over there, that is the act of God. Are you following me?
Yes, sir.
At that
Yes,
instance,
sir.
you cannot bring an action. There is no legal injuries caused over there. Is it clear?
Yes, sir.
So now let us see the Vishnu Datta Sharma versus Board of high school and the intermediate examination. See, in this case, the Vishnudatta Sharma was a student who was wrongfully detained by the principal on the basis of the misconstruction of the relevant regulations on the account of the shortage of attendance. Suppose if you have only the 60% attendance, only 10 will be condoned, because your principal is having every right to not to send your examination form to the examination branch of the university, because you did not fulfill the condition of the 70% attendance. So the plaintiff filed a suit, argued that he was entitled to damages he had suffered loss of 1 year, but the court ruled that the plaintiff cannot claim the compensation as a misconstruction of the regulation does not amount to a tort. You violated it. You did not have the 70% attendance. Hence, the principal is having the every right to retain, not to forward your examination form to the university branch. So please, సార్ మేము ఒక్కసారి పోయినాం సార్, ఇప్పుడు అడ్మిషన్ అయ్యేటప్పుడు పోయినాం, మళ్ళీ పోతామా సార్ మేము? మళ్ళీ ఓన్లీ వీల్ గో ఎట్ ద టైమ్ ఆఫ్ ఎగ్జామినేషన్. వీ డోంట్ గో, వీల్ సెండ్ సంబడి ఎల్స్ టు పే ద ఎగ్జామినేషన్ ఫీ. మరి ఎప్పుడు పోతారు? ఓన్లీ ఎగ్జామ్ డే. ఓకే, ఇఫ్ యూ డూ లైక్ దట్, ఐ డోంట్ నో వై యూ వాంట్ టు స్టడీ ఇట్. సార్ మేము చదువుతానది కానీ డిగ్రీ సార్ పక్కకు రాసుకుందానికి. ఓకే, యూ డూ వాట్ ఎవర్ యూ లైక్ ఇట్. So Mughal Steamship Company Limited versus McGregor and Company. In this also, there are the ship corporation was there. There is a lobby is there, but one of the lobby, they say they reduce the right for the freight, but the Mughal Steam Company Limited suffered a financial loss over there, because the other companies' rates are very much less for the freight, the cargo, but the Mughal Ship Company is more, but nobody is coming forward to load the cargo in his steamship company, and hence he suffered a lot of revenue, and he brought an action against the other companies whose reduced right would be there. But as I told you that in the business, competition is allowed, they can keep the price whatever they want it. But now a minimum thing would be there, fair pricing should be there, some controlling authority would come out there. They now they are controlling it, at least to the maximum and the minimum that you have to maintain in this way. Not to that much extent close. Sir, somebody will say the free of cost from Khambam to Hyderabad transport. Can a person keep free of cost? Yes. Why you are not giving the answer to my question? Yes.
No, sir.
Free of cost from the Khammam to the Hyderabad, and that to be Garuda.
No, sir. No, sir.
Nobody would. Government will come to the rescue. You are not supposed to give the free of cost. At least keep 10 rupees. Okay, 10, 20 rupees, and 20 rupees also not there, because if the only 2 or 3 members are traveling in the Garuda and which is having the AC, and his petrol charges or the charges will not be met over there. Are you following me? So minimum thing would be there now. Nobody would keep in such a way. But another case law, with this I will stop today's. Of course, still we do have some time. Usha Ben versus Bhagyalakshmi Chitra Mandir. It is there where 3 goddesses. Who are 3 goddesses? Women goddesses. Sir, maku telusu sir, మేము నిన్న చెప్పినాం కదా సార్, పార్వతి, సరస్వతి and లక్ష్మి. పార్వతి stands for సార్ మాకు తెలియదు సార్. సరస్వతి మాత్రం తెలుసు సార్, ఎందుకంటే చదువు సార్. లక్ష్మి తెలుసు సార్, ఎందుకంటే సార్ ధనం సార్. Then what about Parvati?
Correct, sir.
Yes. Saraswati for the education, Lakshmi for the money. What about the Parvati?
Money. Courage, sir.
Happy family.
Courage, sir.
Courage. Warrior. Okay, now let us see. In the movie Bhagyalakshmi Chitra Mandir is the production. I don't know whether you saw the productions in the Gemini production and వచ్చే చూసిండ్రా? ఇద్దరు బుడ్డగోషి పెట్టుకొని పిపి పెట్టేది.
Okay, sir.
Yes,
Okay,
sir.
sir. Okay, sir.
Gemini productions, AVM production, have you heard? AV Mitchell.
Yes, sir.
Yes, sir.
Chennai, sir. Chennai.
Old
Okay, sir.
movies.
Chennai అది.
Okay, sir.
Chennai.
Good movies are
200.
there. AVM production and this Gemini production. Very good.
Production
movies.
houses
Yeah. Because I have seen many movies of AVM. So here also Bhagyalakshmi Chitra Mandir, they are the producing the synchronizing the వాళ్ళు పిక్చర్ ఏం చేసిందంటే జై సంతోషి మా సినిమా తీసిందండి. ఆ జై సంతోషి మాల వీళ్ళు ఏం చేసిందంటే ఏది ప్రొడ్యూసర్ దే హావ్ షోన్ డెపిక్టెడ్ ఇన్ ద మూవీ గాడెసెస్ పార్వతి సరస్వతి అండ్ లక్ష్మి దే ఆర్ ఈచ్ అదర్ జెలసీ టు ఈచ్ అదర్ అని చూపెట్టిండు. సో ఈ యూషా బేనే ఏం చేసింది అమ్మాయి సార్ అది జలసి బాగా చూపెట్టింది సార్ అందుకోసమే అది రెడిక్యూల్ చేసింది సార్ ఇన్సల్ట్ చేసింది సార్ అని ఈ ఫైల్ ఏ కేస్ అగేన్స్ట్ భాగ్యలక్ష్మి చిత్ర మందిర్ ఫర్ ఇంజంక్షన్ ఆడ నాట్ టు షో దట్ మూవీ స్టాప్ ద మూవీ ఓవర్ దేర్. But the court said it was observed that religious hurt is not being recognized as a legal wrong. They shown a woman is having some jealousy nature. That is only he picturized over there. Not more, not less. Are you following me?
Yes, sir.
Sir.
Suppose if you are not interested to see movie, don't go. But why do you ask the producer to stop the movie? కొన్ని సెన్సారీ అయితే okay, the censor body will censor it because it hurts the feeling of somebody else. So it was observed that the religious hurt is not being recognized as a legal wrong because generally women is jealousy to each other. Do you agree or not? మీరు ఎంత మంచిగా చెప్పినా మీ గుండె మీద
Okay, sir. Yes, sir.
ఇట్ ఈస్ ఆబ్వియస్ ఫ్యాక్ట్.
I agree.
ఇంత ఇందిరా గాంధీ కదా హైలీ ఎడ్యుకేటెడ్ కదా మదర్ థెరెసా గారి కదా దే ఆర్ హ్యావింగ్ ద జెలసీ టు ఈచ్ అదర్. సో మోర్ బికాస్ ఇట్ ఇస్ దేర్ ఇన్స్టింక్ట్ అండి, వాళ్ళది ఇన్స్టింక్టే ఉన్నదండి, డిఎన్ఏలే ఉన్నది.
Yes, sir.
ఓకే, మోర్ ఓవర్ నో ఇండివిజువల్ కెన్ డామినేట్ దర్ రిలీజియన్ ఓవర్ ద అదర్ పర్సన్ అండ్ కెనాట్ రిఫ్రైన్ ఫ్రమ్ ద పర్సన్ ఆఫ్ లాఫుల్ యాక్ట్ అండ్ హెన్స్ దెర్ ఇస్ నో లీగల్ ఇంజురీస్ కాజ్డ్ ఓవర్ దేర్ but a little religious feeling were hurt by the Usha Ben. The court say if you don't want to see the movie, don't go. I don't know whether you have seen the English movie, horror movie Evil Death చూసారండి మీరు? Evil Death. But don't see the movie in the night because there is this horror movie is there. Very horror movie there is. A man with a chicken heart and if he see it, no, he will go for the urination. Are you following me?
Yes, sir.
Sir.
Please.
Yes, sir.
That's why they make it in the warning. This is only for the adults, not for the, because you know the A certificate, U certificate. U is means universal. A means only
A
adults.
means adults.
The censor body which gives like that. If the many pornography scenes are there, they will detect it. Then they will try to delete them. Because censor board will delete them because it's India is having the cultural and having the cultural society, hence they did not allow to do so. So now let us see, these are the cases, but whenever you are writing the cases, please keep in the mind, సార్ 10 పేజీలు రాసిన సార్, దేనికి రాసినానైనా షార్ట్ క్వశ్చన్స్కి, షార్ట్ క్వశ్చన్కి 10 పేజీలు రాస్తే ఎన్ని మార్కులు ఎత్తారు సార్? 5 మార్కులు ఎత్తాడు. 5 కన్నా ఎక్కువ ఎత్తారండి? Can your examiner will give more than 5 if you write the 10 pages for the short questions?
No, sir.
No, sir.
No.
Please be a prudent man. Be a prudent man. You stretch your answer depending upon the marks. Otherwise, sir, 5 క్వశ్చన్లల్లా అబ్బా ఎట్లా గుద్దినంటే సార్ 3 క్వశ్చన్లు, మిగతా 2 ఏం చేసినారు బాబు? వదిలిపెట్టిన. ఎందుకు వదిలిపెట్టిన బాబు? టైం లేకుండే. Don't do like that. If you don't have the time, attempt the second one by keeping the white pages in the middle. Attempt the third one, but attempt every question. If it is 5 questions to be answered out of 8 or 9 or 10, attempt all the questions. But don't say that I wrote the question too beautiful manner. You cannot get more than what it is. Maximum marks are there. But if you lose it, means you are losing your marks intentionally. Are you following me?
Yes, sir.
Is it in the course outline, sir? Is it in the syllabus, sir? What I said, is it in the syllabus?
No, sir.
Obtaining the marks, sir.
A prudent man should have to suppose to write the way that you want. Can a prudent man spit, sir, sky ki juicy spit jettada andi evadana? Are you following me? Can you spit it looking at the sky to see whether it falls down or not?
No, sir.
No, sir.
Please don't do such an experiment. It falls on your face. Don't do such an experiment. It falls on your face only. Because anything which goes up because of the gravitational pull comes down. Only few things will not come, like very high. The lightweight would be there. Of course, the moon. Of course, moon there is no gravitation would be there. So you can float over there, but not on the earth. So let us see what is the difference between the demnum sine injuria and injuria sine demnum. If you happen to see still video of the 9 minutes in your packet in a wallet, demnum sine injuria refers to the damage suffered by the plaintiff, but no damage is being caused to the legal rights, as there is no violation of it. In damage is there, but no legal injury is caused in the demnum sine injuria. But in the injuria sine demnum, the legal injury is caused to the plaintiff without any damage to the physical injury. So that is the difference between the first difference. The second difference is, it is the losses suffered without the infringement of any legal right, hence creating no cause of action. Because there is no legal injury is caused, even though substantial damage is caused over there in the demnum sine injuria, but the injuria sine demnum, where the infringement of a legal right is there, where if no loss has been suffered by the plaintiff, still creates an actionable cause of action here. Number 3, no compensation in the form of damages is awarded by the court, where in the demnum sine injuria. But injuria sine demnum, yes, the compensation will be awarded because there is a legal injury, even though there is no substantial damage. 4, the maxim is for the moral wrongs which have no action in the eye of the law. See, the maxims of the moral wrongs only. It doesn't have the legal right. Suppose I give the example. If you are a passerby, you don't know the swimming, but a boy is crying, save, save in the swimming pool, but you don't know swimming, at that instant, you cannot do anything. But if a coach is there, if the coach is there, but he says the boy is crying over there, save me, it's a duty on the part of the coach to save the boy. So it is a legal wrong. So the maxim is for the legal wrongs which are actionable if the person's legal right has been violated. I give an example also there. Suppose you are a strict vegetarian, but because non-veg smell is so much good, you have the desire to at least taste one lollipop. What is lollipop in a veg, non-veg?
Chicken lollipop, sir.
Chicken lollipop, that is. Can you do the legal wrong? Because the smell is so desiring that he enjoyed the chicken lollipop. He is a strict vegetarian. Can anybody will bring an action against him?
No, sir.
No.
No.
But
No,
you
sir.
forced him to eat. But you
He-
forced him to drink.
Yes.
Yes, that is a legal injury. That is a legal injury.
Legal injury.
అరే తాగినా మర్చిపోయినావా రావడం? మర్చిపోయానండి. ఎవడైనా బలవంతం చేస్తేనే నేను తాగుతా. మరి వాడెందుకు రా బలవంతం చేయడానికంట? వైరల్ చూసిండ్రా అండి వాట్సాప్లో? Have you seen the viral? It is there. Okay, now see the fifth one. The principle of this maxim is that the person exercises in such a manner with a reasonable limits, which does not ground action in tort merely because the cause damage to other people. So it is merely if the damage is there, there is no legal injury, naturally that he is not going to get it. But here, in the injuria sine demnum, the principle of maxim is that whenever there is an invasion of a legal right, invasion in the sense, violation or contravention of the legal right creates a cause of action, definitely. And the person whose right is vested is entitled to bring an action. Yes, whose right is violated over there, he can bring an action. Suppose somebody will touch you without your consent, you can bring an action against him. Are you following me?
Yes, sir.
Yes, sir.
Yes, sir.
He is a trespass to person, that is. Sir, బస్సులో సార్ వాడు బ్రేక్ వేయకపోయినా గుర్తింది అనుకోండి, ముందట బ్రేక్ వేయకపోయినా పడ్డారనుకోండి, వేస్తాడని పడ్డా అని చెప్పుకోవచ్చా అండి? చెంప చెల్లు అంటది. ఏమంటది? చెంప. In this, the plaintiff suffers a loss but has suffered no legal injury. Yes, that is true. In this, means injuria sine demnum, suffers a legal injury. It does not matter. They have suffered a loss on the ground. Number 7th, damages without injury are not actionable. Because there is no injury is there, but no damages is not actionable. This is actionable since there is a violation of the legal right. Sir, buslo full rush untadi. I don't know whether you sat any time Setwin buslo కూర్చున్నారా అండి? వాడు నిలబడ్డా కూడా ఇంకా నెట్టుతూనే ఉంటాడు. Are you following me? Going from Secunderabad to
Yes, sir.
either you go to GD Metla, you go to the Medipattam, you go to the Sarat Nagar, you go to the Kokatpalli,
Koti also.
you go to the Koti also. ఒక్కసారి వెనక్కి వెళ్ళి ఒక అమ్మాయికి తగిలింది, గమ్మున ఉన్నది. రెండోసారి తగిలింది, దెబ్బ. మూడోసారి కూడా తగిలింది. ఏంటి మీరు ఊరుకోలేరా అని అడిగిందంట. నేను అమ్మ శ్వాస తీసుకుంటాను నాన్న, నా పొట్ట పెద్ద ఉన్నది కదా, తగిలింది కావచ్చు అంటాడంట. Are you following me?
Yes, sir.
See, because he's
Yes,
not
sir.
voluntarily is making over there, because he's such a stout would be there. When you take the breath at the time, బ్రేత్ తీసుకుంటే చెస్ట్ పెరగాల కానీ బుర్ర పెరుగుతుందా అండి? సార్ వాడు ఎక్సర్సైజ్ చేస్తాడు కాబట్టి బుర్ర పెరుగుతుంది సార్. ఎక్సర్సైజ్ చేసినప్పుడు చెస్ట్ పెరుగుతుంది when you breathe in. Okay, now UB just CB remedium, I already told you that there is a legal right, then definitely there should be a remedy. Violation of legal right I am speaking about. When there is a legal right violation was there, then definitely there should be a remedy. So in this way, the maxim is applicable only where the right is in a question, legal right. So a wrongful act must be violated the legal right of a person, only then the cause of action may arise. We will have one, sir, when there is no smoke, there is no fire. Enter. Is it clear or not? Where there is no smoke, there is no cry and no fire. Yes, there would be a smoke, then only there would be a fire. So here, no legal injury is done, the person, the maximum demnum sine or injuria will be applied. But here, a legal injury is caused over there. But yes, he should be compensated. He should be compensated. So here, one of the case law, we will see that still we have 3 minutes. Up to that extent, we will cover it later. We go to the another. Sardar Amarjit Singh Karla versus Pramod Gupta and others. This case is court recognized the maxim UB just EB remedium as a fundamental principle of law. It was held by the Supreme Court that it is the duty of court to protect the rights of the people and to grant relief to the aggrieved party rather than denying it. If a person right is violated over there, he should be compensated. ఒక క్వశ్చన్ అడుగుతానండి, ఐ వుడ్ లైక్ టు గెట్ ద ఆన్సర్ ఫ్రమ్ యూ. సార్, ఎవరన్నా ఐఎమ్ గివింగ్ ద ఎగ్జాంపుల్, ప్లీజ్ టేక్ ఇట్ యాజ్ ఎ స్పోర్టివ్ మ్యానర్. ఫ్లయింగ్ కిస్ ఇచ్చింది అనుకోండి, వెదర్ ఇట్ ఇస్ అన్ అఫెన్స్?
It is an offense, sir.
If you look at somebody and give the flying kiss, yes, it is an offense. The reason is it hurts your feelings, which you don't want. Suppose if she refuses and keep inside, it is a voluntary act. Voluntary not fit injuria. Are you following me?
Yes, sir.
Yes, sir.
Yes, sir.
So when I was teaching the trespass to person, I will say the same example. A unwanted kiss is a battery. A unwanted kiss is a trespass to person. So that is an example, we can say it. By this we can stop today's class, and tomorrow we will go to the DK Basu versus State of West Bengal case law. It is the custodial death. It comes under the constitution also. Please read such cases, which will be very much useful both in the constitution and the various other places also, because the same case law you could use it in different places. Like I told you, the HB versus case law, you can use it in the nominal damages, you can use it in the UB just CB remedium,